Hi, my name is Alex Dolphin and welcome back to another episode of Ex Ante. Today we're going to discuss the case Kahn versus MFW. This case was heard in the Delaware Supreme Court in the year 2014. To understand what this case is about, we need to know what a freeze-out merger is. A freeze-out merger, often referred to as a cash-out, a squeeze-out, or a going private, is a specific type of merger that the corporate law has developed some doctrine around, and that's because there is usually a duty of loyalty problem in a freeze-out merger. So let's show you what that duty of loyalty problem might be. So in a freeze-out merger, you have one corporation, Corporation A, that is owned by a myriad of stockholders, but there's one controlling stockholder. So someone that can essentially make this corporation do whatever it wants. This controlling stockholder in the corporate law owes fiduciary duty of loyalty to these other stockholders. But what this controlling shareholder will do in Corporation A is they will force a sale of this corporation from these stockholders to Corporation B, which is one that they completely own or have a large share in. And so you can see how this might be seen as self-dealing when you are forcing a corporation that is owned by a myriad of stockholders and you're just one, but you're the controller, to sell itself to another entity that you have an interest in. This might have a duty of loyalty problem because you might be, as the controller over here, taking advantage of the minority shareholders. And so the corporate law has developed the standard of entire fairness for a myriad of contexts, but here where it is self-dealing, if we detect self-dealing, and the default in these freeze-out mergers is that they're going to be subjected to entire fairness review. And so if you watch my video on Sinclair versus Levine, that case we talked about how entire fairness is applied when there's self-dealing, and that's a very high standard that is going to have to be satisfied if a corporation is or a controlling stockholder is trying to explain itself in court. And so you have in this case a controlling stockholder, M&F, in another corporation, MFW, and they essentially do a freeze-out. They are selling MFW to M&F, and they're going to take it private. Ronald Perlman is the controlling shareholder. He's the controller here. But he consults with some attorneys before they do this freeze out. And basically he's like, the attorneys are like, well, there's going to be some problems here, but we can try and do something where we can get around the entire fairness standard. Hasn't been done yet, but we're going to try and get around the entire fairness standard and get you to business judgment review, which is a much more deferential standard. And so these ingenious lawyers basically cook up this plan with litigation in mind the whole time while they're doing this freeze-out merger. And what they do is, traditionally, the entire fairness standard can, kind of be rebutted in a sense. It will the burden will get shifted to the plaintiff if the controlling stockholder and the selling corporation basically gets approval by a majority of the minority of the shareholders, or they create a special independent committee to evaluate the sale. And if you do that, then you can shift the burden to the plaintiffs, right, to say that this was not entirely fair. So that's, traditionally what corporations had done. But these lawyers said, what if we do both? What if we get a special committee and we get a fully informed vote of the majority of the minority shareholders here? And they were hoping that if they did both of these, they could get away from entire fairness review and get to business judgment review. And that's what the Delaware Court of Chancery did, and that's also what the Delaware Supreme Court affirmed here. They said in the limited scenarios, we are going to allow you to avoid entire fairness review and get to business judgment review. But you have to jump through both of these procedural hurdles, and you've really got to do it. It's got to be good. The facts have to show that this special independent committee was fully empowered, was fully independent, had no material dependence on any of the conflicted or interested shareholders. And you've got to show us that they actually negotiated. They actually did what they were saying they were going to. And you've also got to show us that these minority shareholders were fully informed when you sent them this vote. And so here they say, yes, MFW, you met this very high standard when you sold yourself away. So what did they do? Well, you had Ronald Perlman. He was basically on both boards. He was on the board of M&F and he was on the board of MFW. Ronald Perlman is a very wealthy investment banker. and he sat on both sides of this transaction. There were also two other directors that sat on both sides of the transaction. They were on the board of M&F and the board of MFW. And so when they were setting up this independent committee, those guys were just not involved. They were off the special committee. They couldn't really talk to anyone. They could not, discuss anything that was going on here. Essentially, the first offer was for $24 a share, and at that time, MFW was trading for $17 a share. So you can see that it's a bit of a premium. That was the first offer, and the special independent committee considered that offer, and they got advisors to entertain that offer. They didn't just willy-nilly say, "Yep, that's good." They got Evercore, an investment bank, and they also got a law firm to help evaluate this offer. See, is this fair for our minority shareholders? And they went through the process. They actually negotiated back and forth. They said, "Hey, no, we want $30 a share." And the buyer said, "No, we're going to give you 24." Eventually, they settled on 25. But the court saw that, yes, there was a fully empowered special independent committee that was negotiating on behalf of these minority shareholders. And there weren't conflicted people in here. The plaintiffs try and argue that these people were, dependent on Ronald Perlman and the other directors. But that's not the case, the court says. We have to look at a materiality standard. And it was not a material type of dependence. Being just friends on the board is not enough to say that you are a conflicted or dependent director. So they say, yeah, this special committee here, they did its job, and that was good. MFW completely jumped through this first hurdle, this first procedural hurdle. And then they also say, yeah, there was a fully informed vote by the majority of the minority shareholders here. So MFW satisfied both these prongs. And so we are going to subject this freeze-out merger to business judgment review. That is much more deferential. I mean, that is a huge deal for MFW to be able to get to that standard, because then the court basically is just going to have to sign off. They're not going to challenge that too much. BJR is very deferential to the directors. And so essentially, by going through these procedural hurdles, MFW evaded entire fairness and got their merger, completely court sanctioned here. And so, you think about forward, what would this decision have going to the future of freeze-outs under Delaware law? Well, if you're going to do a freeze-out, you probably want to follow this method, right? You're probably going to want to go through both of the procedural hurdles to get away from entire fairness review, which could be very, very dangerous for you, because we're talking about price. And this is after the fact, looking back, was that price completely fair, and was the dealing completely fair? And I mean, is that something that you really want a court to entertain? You want to get two experts up there and someone says it's worth $25, the other person says it's worth $30, and then the jury just has to look at it? Probably not. And so you can avoid all of that pain and all of that suffering and get your merger just sanctioned by jumping through both of these procedural hurdles. But you've got to do it right, the court says. There's no shortcomings. You can't just say you've done these things but don't actually do them. You've got to have facts that show that independent committee was empowered, that it actually negotiated on behalf of the minorities, and you've also got to show that vote was fully informed. But also just thinking about this case, it's like, yeah, MFW and future freeze-outs, they get around entire fairness, but they're basically just doing entire fairness before the fact. I think that's why the court's okay with it. How can you not say that this was entirely fair? It was. And so now we're just going to subject it to BJR because they jumped through both of these procedural hurdles. It looks so fair to us that how can we subject this to even a further standard of entire fairness? I think that's partially what's going through the Delaware court's minds here. So thanks so much for watching. I hope you enjoyed this video. If you'd like to see more, go ahead and hit that subscribe button. And I hope you have a nice rest of your day. Bye-bye.